Welcome back to the afternoon session of the Law&Crime Network. I'm Linda Kenny Bodden. We have just completed the closing arguments by both the prosecutor and the defense in the case of Amber Guyger, where she killed Botham Jean. Oh my God, you can't see it, but I do have a little tear over here to the left of my eye because it was moving, and more moving. But to take some of the stress off me, I'm going to actually put it on some of my guests, and I am pleased to be joined with the most amazing guests today. I want to start with my very special guest, who represented the Trayvon Martin family in Florida. She's been a friend of mine for many years now. Natalie Jackson, welcome to the Law&Crime Network. Welcome to the afternoon session, and we are so pleased to have you here to discuss the case of Botham Jean, who was murdered, as the jury said, by Amber Guyger. Thank you. Yeah, and I have to ask you some questions, obviously. When we saw yesterday these posts, that many people post funny things on their accounts, their social media, but specifically there were 3 posts. One was, I wear all black to remind you not to mess with me because I'm already dressed for a funeral. And then Amber Guyger mimicked what she thought, I guess, was what she thought minority language. I won't repeat all of it, but it said, yeah, I got me a gun, a shovel, and gloves. If I were you, back the bad word, obviously, up and get out of my backside, so to speak. Another one, stay low, go fast, kill first, die last, 1 shot, 1 kill, no luck, all skill. You know, and then one that's just pretty bad, I think. No one ever thanks me for having the patience not to kill them. All right? When you saw these as a person, as both a defense lawyer, as a civil rights lawyer, as a human being, what did you think about the depravity in the mind of Amber Guyger?
Let me tell you, Linda, I think for anyone else, these texts may not be, and these messages might not be as persuasive or as bad, but when it comes from a police officer, someone who has the right to take life and liberty, and then you apply it in this case of an off-duty police officer who is going in guns blazing, I think that it's really, really bad.
Now, we have an anchor here, Aaron Keller, who was really upset about the applicability of the Castle Doctrine, even under Texas law, which appeared to give any building that had units in it, such as apartment units, the right to, that you don't have the right to, you know, back off, so to speak, okay? Applicable to Amber Guyger when she didn't live in Beau's apartment. I know you were also incensed about that. Why?
I was, because I've seen what can happen when you allow jury instructions that don't apply. And luckily, this jury was smart enough to get it and to know that this just did not apply. But I have been in cases where other jurors, maybe if they have a preference for the defendant or want to have some wiggle room to excuse the defendant for someone, let's say George Zimmerman and stand your ground instruction, you know, it gives them that wiggle room. So that's why I was so upset about that. Obviously, it was Mr. Jean's castle. It was not her castle. So she doesn't get that defense. That, you know, she doesn't get the Castle Doctrine defense.
And finally, one of the other things I want to bring up with you was what they just charged today. The defense asked for this sudden passion charge, which if you find, if the person killed here, Mr. John, had done an act that gave some sudden passion to arise in Amber Guyger, the jury could give her a break of 2 to 20 years. Now, the defense then said they didn't argue it, but the prosecution addressed it. Why do you think they addressed it if the defense didn't argue it after it's in the jury charge?
Because it is in the jury charge, and I think that the prosecution argued it because it's just going to piss the jury off more. This jury, if you're telling this jury that Mr. Jean caused his own death because of his provoking of her, I think that, you know, that's the same reason the Castle Doctrine was rejected. And I honestly think that putting these in the instructions is actually hurting the defendant, not helping her.
So yes, Natalie, let me have Gene Rossi, who was a federal prosecutor for maybe more than a year. No, I'm just kidding you. Gene Rossi, who we love here, Law and Crime legal analyst. I have been saying that I think the defense hurt their client by having all this garbage thrown at the jury, that the jury knows they're from the community. They know that there was an attempt early on, as the family had said or believed, to dirty Botham Jean up, who turns out to have 26 years of nothing but good on his side. Goodness, goodness, and more goodness. What say you, Gene Rossi, as a trial lawyer perspective?
Well, I want to say I agree with Natalie that in this case, I've had others where it's the opposite result. I think in this case, because there were what I call gratuitous jury instructions that clearly don't apply, and that the defense was arguing it so strenuously, I think Natalie's right. It could have backfired. But I want to say something else that may have backfired, in addition to having a defendant testify, is they split up the closing, the defense did, and I thought the first prosecutor, Shook, I think his name is, he was doing this relatively good job, and then they had this other guy do the final, the last half. I thought that took away some credibility because it looked like they both were trying to get their name in the paper or something.
You know, Gene, you bring up a point that I say to a lot of lawyers when I teach them, that the case shouldn't be about you. It's about your client. And sometimes lawyers forget that. They tend to think that the case is about them being in the news, and it's not, right?
Absolutely. And I want to go to what Natalie said about jury instructions. You know, I have had, I can think of one, where a judge did put in a jury instruction that was totally inapplicable, completely, but the jury bought onto it because they were sympathetic to the defendant. This was different. I think the jury concluded this. She did make a mistake when she got to the front of that door, but then she realized this isn't my apartment and thought there was a burglar inside. And you're right, she had some anger issues from the guy escaping. She went in there, guns blazing, and she murdered him.
And Gene Rossi, the point I want to bring up with Joe Scott Morgan, and I know my other guest, Katie Smith, is here, but I'm going to save her probably for the next time we talk because she had an amazing aha moment last week. But Joe Scott Morgan, we're seeing the apartment right now. The angle of the shot being from top to, it was actually the left side down here. That angle can't occur unless she's past that countertop, can it, Joe? Joseph.
Yeah, I think that it would be probably physically impossible. The laws of physics kind of state that this is the reality that you're looking at relative to this trajectory. It passed superior to his left nipple. It stayed on the left of the midline the entire time.
Joe, I got to stop you for a second. There was a press conference by the family attorneys going on right now. Let's listen.